Hi, I'm Rick Durfee. I'm an attorney. I've been practicing law since the 80s. We constantly get a stream of questions from the internet. We're going to tackle some of those today. Can my kids lose their inheritance if they get divorced? And the answer is yes, if they're stupid. And I'm sorry to be so harsh, but what we see happen all the time is people get an inheritance and they don't bother to protect it. By law, in all 50 states, an inheritance, when you get it, is the separate property of the one who inherited it. But it's really easy to clobber that separate property status. If you commingle it, if you buy things together with a spouse and you don't document it, if you don't keep track of it, that can end up being commingled, treated as an implied gift or an in fact gift to your spouse. So it's no longer a separate asset, it's now a marital asset, and the spouse can get half. So, as an example, some years ago, I had a client who said, "Oh, I'm not going to pay all those legal fees." And we had an issue where there was life insurance that was going to be included in the taxable estate. So he had one of his two sons buy the life insurance policy and pay the life insurance premiums. And every year, Daddy would send him a check to pay the life insurance premiums, and Junior would deposit that check in the only checking account he had, which was a joint checking account with his wife. And he kept no records. And his wife had access to the money. And then he paid the premiums on that life insurance policy. And then Daddy died. Junior collected the life insurance. And then wifey said, "Well, I've been unhappy in our marriage for a long time and wanted to divorce you, but it was never worth it until now. Give me half the life insurance." And because the premiums had been paid from their joint checking account, she won. Then the brother came to him and said, "Hey, where's my half of the life insurance?" And he said, "Hey, my ex-wife got it. There's nothing for you." So family drama was very nasty. You can lose your inheritance if you do not structure your assets correctly. Your children can lose it, which is, by the way, one of the reasons why a dynasty of trust is attractive, because if assets are held in an appropriate trust structure, they can be protected from the in laws. Next question. How do I prevent my spouse's future spouse from getting my assets? Well, we just mentioned one of the big ways. An appropriately structured dynasty trust can protect the assets that you leave to your children from your children's spouses. In the classic estate planning structure, the money flows down through the family line to the blood. So the blood descendants get the money, not the in laws. The in laws can be locked out. Now, the in laws receive benefits and enjoy being a part of the family as long as they're part of the family. But if one day they pick up their belongings and march out the door and say, "I'm out of here, I'm not going to be part of this family anymore," they have to leave their inherited assets behind if they're held in an appropriately structured trust. Next question. Can my ex get access to my trust? Well, it depends. One of the things we encourage people to do, especially when they're marrying later in life, when it's a second marriage or even a first marriage, but they've already had time to accumulate assets, they may have a business, they may have a house, set up a trust before you get married, because then you have a bright line. Here's this trust. It was in place before I got married, and it owned things. It owned my house, it owned my business. It's not as solid as a prenup, but it goes a long ways and does many of the things that a prenup does. And sometimes that can be sufficient to protect the assets from a questionable marriage. The other thing I'm going to say is marry well and stay married forever, and then that's just not an issue. Who makes decisions for me if I'm alive but can't speak for myself? This is a huge issue. And this is something that's not an if question, it's a when question. Even if you manage to stay alert and cognitively active and high functioning clear to your last breath, even if it's just for a few seconds, there's going to be some point at which you cannot speak for yourself. If you have not designated the legal authority to people that you have selected in advance, the people who end up making those medical or legal decisions for you will be somebody else. And the mechanism is typically we have to go to court. We have to go and have either a conservatorship or a guardianship And the precise meaning of those two words can vary a little bit from state to state. So you need to look at and consult with state people who know what they're doing. But the bottom line is you have to get a court order appointing someone with the legal authority to make that decision. And we've seen people, I've actually lived through this with family members of clients, where they did not have these documents and a much needed medical decision was deferred or delayed, often to their detriment, because no one had legal authority to make that decision. So there are some basic legal, medical, and emergency documents that everybody over the age of 18 should have, where those decision makers are designated. For financial decisions, it's going to be a financial power of attorney or a durable general power of attorney. For medical decisions, it's going to be a medical power of attorney or medical directives. Again, that language can vary a little bit from state to state, and typically a living will, which addresses end of life questions. At what point is someone too crazy to make their own decisions? Well, let me say this. Crazy has nothing to do with it. I once was in a court proceeding where we were in fact debating whether or not someone should have a decision maker appointed on their behalf by the court. And this is what the judge said, and I'm paraphrasing, but quoting as closely as I get. A person can be stark, raving, howling at the moon crazy and still have capacity to make their own decisions. And the threshold for what are called testamentary decisions, which is who gets my stuff when I'm dead, or who do I want to delegate authority to make decisions on my behalf, is actually pretty low. Do you know who you are? Do you know who the natural objects of your affection are? Oh, these are my family members. Do you know what you have? And do you know what you want to do with it? For example, I know that I'm me. I know that this is my daughter. I know that I have a bank account and a house, and I want to give my daughter the power to deal with it. Now, does that mean when you sign that document that is 12 pages long and lists out all kinds of things that you have to understand every word of that document? No, you understood who you are. You know that that's your daughter. You know you got stuff, and you know you want to put her in charge. That's enough. So it's a very low threshold to sign that. Now, if on the other hand, we had a situation where our client's ex-wife went to his mother, who was heavily medicated and on her deathbed, and held her hand and had her sign documents disinheriting her own son and giving it to his ex-wife. Guess what? Those documents failed because clearly she did not know what she was doing. She was not conscious, and it was fraudulent. So you have to have those elements. You have to know who you are. You have to know who the natural objects of your affection are. You have to know what you got, and you have to know that you are giving up authority or giving authority to this person. You're delegating authority. Being crazy has nothing to do with it. You can be Looney Tunes and still exercise that power. Can I cut someone out of my will and will it hold up in court? Well, yes, but is that the best way to do it? Generally speaking, and some things that don't work. If you want to cut somebody out, cut them out all the way. Don't give them $1, because if they're $1, they are then a beneficiary, and beneficiaries have certain rights. You want to say, I'm cutting them out and they get nothing. And you want to, in my experience, do a couple of things. You want to explain why. I'm cutting this person out because fill in the blank. We've been out of contact for decades. I don't even know if they're alive or dead or whatever. They didn't come to my birthday party and now I'm mad at them. Whatever your justification, they have enough money, they don't need mine. I have another family member who needs it more than them. Whatever your reasons are, spell it out. Number one. Number two, you tell them. Don't leave it up to your lawyer. I have had the unhappy experience of having to go to the children of a client who's passed away and say, oh, I'm sorry, your mom or your dad disinherited you and they're skipping you and it's going to your kids, or they're skipping you altogether and it's going to charity, or some other deal. And guess what? They're always mad when you do that. And it does them no good to be mad at the lawyer, but they will be mad at the lawyer. So don't put that on your lawyer. You tell them. If you're going to have the cojones to disinherit your family member, have the cojones to tell them to their face so that they're not left. Now, obviously, if you haven't had contact and you don't know where they are, you can't tell them personally. But if you're going to disinherit people that show up for family events and that you have conversations with, you need to let them know. If I leave everything to one of my children, can the others sue? Well, yeah, they can. Guess what? Anybody can sue anybody anytime for anything. The question is, will they win? And often it doesn't matter if they will win. I have seen family members do crazy things with litigation that just blow my mind, actually. We often tell people, don't fight, don't fight, don't fight, don't fight. Talk nice to each other, resolve this kindly and peacefully, because if you fight, we're going to make you pay. And they'll say, fill in the blank, emotional diatribe against my sibling that for whatever reason I don't like, and I don't want them to get whatever I think they're getting that's unfair, and I'm willing to fight about it. And candidly, that's a nice revenue source for our firm and a lot of other law firms. Don't go there. We have better ways to make money. If you're on the inheriting side, work it out with your siblings, don't fight. But yeah, if you disinherit a child, your other children who are disinherited can fight about it. Now, there are some ways to mitigate that. One is using a trust and having built into that trust mandatory alternative dispute resolution provisions. That doesn't prevent the conflict, but it designates the forum, the venue in which that conflict will be resolved, and the procedure by which that conflict will be resolved. So it will get resolved, hopefully, faster and cheaper with a lot less heartache. When somebody gets disinherited, plan on them disputing that because they won't like it. That's another reason, by the way, to tell them yourself while you're alive, oh, by the way, I'm not leaving anything to you because this other family needs it more, or whatever your reason is. What actually happens if someone dies with no plan at all? Well, first of all, anytime anybody dies, that's sad. We need to acknowledge that. And that's emotionally difficult. So the survivors, the family members of that person who passed away, are going to be in an elevated state of emotional stuff. It's going to be tough. So if you compound those already challenging emotional difficulties with money and property difficulties, the problems get exponentially worse. So if there's a bank account, if there's real estate, if there's a company, it gets nasty to unwind it. Often one of the consequences is that we have to go to court. We have no choice. So if a person dies and they have money in the bank, they own real estate, they have a business, and they don't have a plan, well, the only person who can deal with those assets are the dead guy. And that's kind of a long distance relationship to manage your property. It really doesn't work all that well. So there's no living person who can manage all that stuff. So we have to go to court and we have to say, Mother, may I pretty please ask a judge to appoint somebody to be in charge and tell us who's going to get the stuff. And if you have no plan, once again, the plan that the politicians have put together and codified in statute, that's the plan that's going to control. And if you don't like that plan, guess what you can do? You can sue about it. So one of the places where we see a lot of conflict is where there is no plan and the people don't like the plan that's being imposed upon them. So they go to court and fight and say, please do something other than what the statutes mandate. So dying without a plan is really unkind. It's unkind to those that you leave behind. Even if you don't have children and it's going to your siblings or it's going to nieces and nephews or it's going to charity, have a plan. We recently administered the estate of a gentleman who passed away, no children, no nieces and nephews. He was the last of the line in his family, and he very generously provided for a number of charities. And because he had a plan in place, it was, relatively speaking, seamless and cost effective. It was administered quickly. The final taxes were paid. All the loose ends were tidied up. The administrative costs to pay the lawyers and the CPAs to do what they had to do to wrap up the estate, it didn't take long and didn't cost very much. And the charities got the money, which was awesome. If it wasn't that way, I've seen charities litigate with each other. Wait, you get this? Well, we should have gotten that. So even non-family members can sue each other over how your estate gets divided up. So dying without a plan is unkind and cruel. Have a plan. If you go into a room, know where the exits are. And guess what? The probability of death is 100%. You're going to die. Plan on it. By the way, planning for it does not hasten its arrival. In fact, quite the contrary. Those who have planned for what will happen with their estate when they pass tend to live longer and live better. So don't let the idea of planning for what's going to happen with your stuff when you're no longer here to enjoy it prevent you from making a plan. It's the right thing to do. We love to answer questions. Give us more, we'll answer them. Check out our videos and our articles online. We are taking clients. We have a queue. There is a link to the wait list in the description below. Click on that link and we'll get back to you as fast as we can.